Hello, everybody. Welcome to another edition of Colonel Jack Spade's Cannabis Destination News. And we have Massachusetts story coming out of Massachusetts. Court confirms marijuana aroma does not justify car search. That's huge. I think it's a big thumbs up. I'm glad that they made this decision because I think it's pretty bogus. It's like that they would be like, oh, you smell. They can just say it. They don't even have. They have no proof. They just say, oh, I smelt it, and there's no actually way that they can prove that they even smelled anything. So I am glad that the courts did this. So the Supreme Judicial Court Wednesday said that well, this is a couple days old, so it wouldn't have been this past Wednesday, I believe. It was, let me look, let me get my dates right. Yeah, Wednesday the 9th, I believe, of July, this happened. So the Supreme Judicial Court Wednesday said that because voters decriminalized small amounts of marijuana in 2008, police officers in Massachusetts can no longer rely on the odor of unburnt marijuana to justify searching a person's car. And two unanimous rulings, the state's highest court said they had already decided in 2011 that the odor of smoked marijuana by itself did not provide police with probable cause to stop people on the street or search the vehicles of people are riding in. Ideas: how privacy became an American value. The court said in its 2011 ruling that it would be legally consistent to allow police to make warrantless searches after they smell burning marijuana when citizens had decided through a statewide referendum questioning that law enforcement should focus their attention elsewhere. The court said Wednesday, July 9th, 2014, it was now extending the same reasoning to cases where the owner has not yet started smoking it. Marijuana, the court acknowledged, generates a pungent aroma, but an odor by itself does not allow police to determine whether a person has more than an ounce with them. Possession of an ounce or less of marijuana is not a crime. So when they smell it, they cannot mess with you. So the 2008 initiative decriminalized possession of 1 ounce or less of marijuana under the state law and accordingly removed police authority to arrest individuals for civil violations. Justice Barbara Lent wrote for the unanimous court, we have held that the odor of burnt marijuana alone cannot support probable cause to search a vehicle without a warrant. Now, we hold that such odor of unburnt marijuana standing alone does not provide probable cause to search an automobile. The court established new legal standards in the case of Matthew W. Overmeyer, who was arrested by in Pittsfield by police investigating a car crash. Responding officers noticed what the SJC called a very strong odor of unburnt marijuana. Police found 1 bag of marijuana in the glove box of Overmeyer's car and a backpack holding even more, leading police to charge him with possession of marijuana with the intent to distribute. The court said police could not, under their nose alone, to arrest Overmeyer. So the police said could not use their nose alone to arrest Overmeyer, but might have had another legally approved base for searching his car. They ordered the case back to the district court for more proceedings. In the second ruling, the SJC throughout criminal charges of illegal possession of ammunition and illegal possession of prescription drugs filed against Anthony Karan, I think is how you say it, was stopped in Dorchester in 2010 by state police operating a sobriety checkpoint on Gallivan Boulevard. A trooper ordered Anthony to pull over based on the odor of unburnt marijuana, and then found 3 ecstasy pills, a 38 caliber ammunition after searching his car. Anthony was not arrested at the time, but summoned into Boston Municipal Court. The SJC said police had no legal basis to search Anthony's car and ordered the evidence against him suppressed. The court also rejected the argument from law enforcement that local police can use the odor of marijuana to stop someone because possession of marijuana is still an offense under federal law. The fact that such conduct is technically subject to a federal prohibition does not provide an independent justification for a warrantless search, Len wrote. So, I think that's an awesome thing for residents of Massachusetts, that that the police cannot go alone on their nose, say, oh, I smell marijuana, whether it's burnt or unburnt, whether you smoked it or didn't. They cannot search you and see what you have and how much you have. That they cannot do on that alone. They are not allowed to use that as a reason to search you or your vehicle or your home. So, therefore, I'm pretty sure it would cover your home too. It doesn't say in this article and whatnot that it covers the home, but I would imagine it would cover your home, it would cover your car, and it would cover yourself. That they cannot alone go on smelling smoke or go along on, unburnt, unused marijuana. That they cannot. So I think this is good, and I'm glad to hear that the judges are upholding what makes sense. It's like, why would it be one but not the other? Why would it just be, if it was burnt that they couldn't, but if it was unburnt that they could? So it makes sense that it's both, because it should be that way. So there you have it. I hope you enjoyed the Cannabis News Now by myself, Colonel Jack Spade. Like the video, subscribe to my channel if you like the content. Leave a comment below, let me know what you think, and have a wonderful day. Hope you enjoy the video.